Well, good afternoon, everybody, and thank you, Gabriela, for inviting us for this presentation in this afternoon. I am Yadira Rivera. I work for Assurance. I am the legal director for Latin America, and I'm here with a great colleague from Brazil, Mateus More Carreteiro. Welcome, Mateus.
Thank you, Yadira. Thank you for the introduction. It's a pleasure to be here. I would like to also thank Gabriela for the invitation. Thank you for the invitation to do this session. And I hope we have a great conversation this afternoon. Thank you.
Yes, definitely. Me too. So, Mateus and I, we're going to talk today a bit about what regional agreements look like and regional agreements when you have multiple countries, in particular in LATAM, and a perspective from an in-house counsel, which is me, and of course from outside counsel, which is Mateus. And it's the perspective you will have from an in-house counsel, and also the perspective from an outside counsel in terms of what do you need to take into consideration when you are dealing with a regional agreement or would like to have a regional agreement to close a commercial opportunity in an insurance company. So as I was saying, as in-house counsel for insurance companies in Latin America, we sometimes are presented with opportunities to offer insurance or protection products to clients with presence in multiple countries in the region. When such opportunities arise, you get very excited and begin planning to close the opportunity. And as part of such plans, one of the first things to do is to work closely with the commercial teams to understand the details on the opportunity and align on strategies. But it is also important to identify the relevant aspects, of each of the countries involved in the opportunity. That means from a compliance and legal perspective, you need to conduct or lead efforts to research each jurisdiction. So first, you might think about identifying the type of business opportunity. What insurance products or protection products are you offering? Are you offering a service instead of insurance? Or if you're offering insurance in one jurisdiction, it might be considered a service in other jurisdictions or countries. So what are the implications of this difference? These aspects will certainly determine where and how to research. So the research in each of the jurisdictions will be required to make sure your program complies with the different requirements in the countries. As you know, each jurisdiction has its own particularities, laws, regulation, culture, need to get regulatory approvals. Other jurisdictions don't require regulatory approvals. So while you're planning to be conscious, need to be conscious and consider those differences in order to successfully implement the program. So what to do next? Very soon in the process, you should seek legal advice that in particular counsel in each of the countries that are experts in the jurisdictions involved and how to best identify such experts. That's where you go to the different law firms that maybe you already know, or you get a good reference from other law firms that are not necessarily experts in the particular business that you're about to close. And then through those law firms, seek out who is the expert on insurance, in particular for the deal that you're researching. Consider also the relationship with the regulator and if regulatory approvals are needed. Also, it is sometimes a good idea to consider one law firm that have branches in other countries or business partners in other jurisdictions. So not necessarily that the firm has a presence in all the countries, but they do certainly have good relationships with other law firms that are in country. And this, if you choose this particular scenario where you have one law firm that will aggregate all the opinions, it will be efficient because at the end of the day, it will be very efficient to digest and implement the results of their research more efficiently. So with this background, I now turn to my colleague, again, Mateus Amore Carreteiro. Mateus is from the Beirano Law Firm, and he is in Sao Paulo, in Brazil. And very glad to have you here again, Mateus, and have your perspective on from an outside counsel perspective and with this background. What's your first reaction when a client comes to you and seek legal advice on a regional opportunity? What do you want to know, and how can we better explain what we want?
Thank you again, Yadira. I think you already did a great introduction and a great overview from our in-house counsel perspective on regional agreements. And just for some clarification on terminology, when we talk about regional agreements, I can also find references as umbrella agreements, master agreements, framework agreements, always meaning that is an agreement taking consideration general terms or guidelines on how a project will be performed, on how the contract will be performed. So going back to your question, I think that first of all, I need to understand when I get an email or call from a client who wants to talk about a regional agreement, you should not understand only the problem that the client has, but I think the overall idea. It's much more than a specific issue because you're talking about, generally speaking, several jurisdictions, you're talking about several people involved, you're talking about sometimes service, sometimes products, but overall, it's not necessarily one small thing or one service or one product. It might be several. And so the full picture, it's really important. And I think when you mention the necessity of having maybe one outside counsel taking care or being responsible to supervise the negotiations on all jurisdictions, it's important because of that. Because if you don't have uniformity on the information, you might not be able to actually have the full picture, understand what's happening in all the aspects. And then the whole idea of having a master agreement, a regional agreement, an umbrella agreement to cover and give you the full framework on how your contracts will be performed may be lost by miscommunication or any other problem. So upfront, I think the good idea is to have uniformity on information and on how the agreement should be drafted and what the actual needs, not only from the perspective of the entity who will be responsible primarily to negotiate the agreement, but also for the other entities that that a specific company is involved in and dealing with. So it gives more complexity because you're not looking only at from one perspective, but you are looking from several perspectives and trying, of course, to gain or to have more leverage on the negotiations or being able to negotiate better because you're taking in consideration only one agreement instead of several. So that's the main purpose. And it makes harder to negotiate in the first moment, but in the second moment, I think it gets, it's where it pays off because you're gonna have a much more smooth relationship, much more fluid relationship and negotiations. So I think the point you touched before about having uniformity of information and having someone that knows everything that's happening and all the needs involved in the negotiation, I think it's the key element, both from the in-house counsel perspective and also the outside counsel perspective.
Yes, definitely, Mateus. When you know, when we as in-house counsel seek out this type of advice, it is paramount to be all clear on the relevant details of the deal and much more. From an in-house perspective, we also expect outside counsel to provide details on different aspects, such as if the deal in general terms, if is possible, if it's not possible, then what alternatives can be worked around for the deal to work, how the design of the deal affects the rights and obligations of the insurer, how to pay claims in the different countries, present the tax impact of the deal as well, foreign exchange risk, who should own that risk, privacy matters, which are definitely very important facts and different in each jurisdiction among many others. But also another important aspect to consider is which entity is more appropriate to enter into that agreement. This is particularly relevant when you have multiple legal entities in your company, both in country and other entities domiciled out of the country. So in that particular scenario, which entities to engage, what drives choosing a particular entity, Mateus?
Yeah, I think you just mentioned something that is key, and that's why the conversation between in-house counsel and outside counsel is important, because the in-house counsel is the one who really knows all the entities that will be involved, how it will be involved in the case, and how to better take advantage of the different perspectives. Because when you are thinking about a regional agreement that will involve several entities, you are considering the master agreement where you're gonna highlight and establish the main principles, values, main characteristics of the agreement, but you also need to take in consideration who will actually, or which entity will actually, at the end of the day, be receiving or giving orders, specific orders on the future services or products. So the answer is, as lawyers love to say, it depends a lot on how it will be structured and which entity will be the one most affected. Because when you take into consideration multi-jurisdiction regional agreement, for instance, and you are considering tax, and I'm saying this based on my Brazilian experience and as not a tax lawyer, but usually the entity who receives the service or who receives the good will have some sort of tax implication, or paying or not paying tax, and not necessarily the entity which negotiated the master agreement. The, this specific entity may be affected because of the orders that you issue or not, depending on how the deal is structured. So besides the general provisions, and that's the main purpose of having a regional agreement, a master agreement, to establish these general clause, general provisions, um, provisions that will be applicable to all entities. And from the perspective of the main entity, of the mother entity, you will be able to protect or guarantee compliance with the rules of the company, which is very, very important nowadays. You also need to take in consideration who will be actually requesting such service products, and therefore issuing the main orders. That's basically the part of the future of the contract, because you regulate the framework, but you don't regulate everything. You leave everything for the specific orders. So this is something that only a very good conversation between in-house and outside counsel will be able to show and help the parties to better address the topic, mainly taking consideration that firms in general, full service firms, have several specialists inside in all the fields, but they don't understand well. They should understand well, but if there's no good communication, they don't understand well the business of the client and the needs for that specific case. So in very short, it depends a lot which entity will be better fit, but you need to take in consideration all those aspects from the framework relationship, more general, and also the specific orders related to the agreement.
Yes, definitely. That part of choosing, the entities, it can be challenging, and depending on, the implications of choosing one entity instead of another. So definitely food for thought around that. Another important point to consider, and we've been talking about this, is, this framework agreement. Is it advisable to have just one uh, agreement, master agreement, one per country, one master plus schedules per country? What's your vision on that?
Yeah, I think the main idea here is to try to have actually one master agreement and leave for the specific jurisdictions, for the specific countries related to the regional agreement, the orders, specific orders related to services or goods to be acquired. Therefore, you get the real advantage of the master agreements, which is basically bring uniformity in the part of the negotiation, and also in the performance of the contract itself, and how it is how it is the day by day business. So this master agreement will have provisions, or I can say three main types of provisions. The first one's to determine the process of agreeing and executing the orders. The second one on what provisions will be incorporated in these specific orders. And here, when we are talking about the second category, I think it is where it gives a lot of comfort to the company to know that every order will have the same treatment in terms on how communication should be done, on compliance rules, and many other aspects that make from, and you can imagine the life of a contract manager having more uniformity on how all those orders should be performed, how his life will be easier, right? So I think this is very, it's a key category of provisions for these agreements, because you leave the specific orders for the future, but at the same time, you already established the framework necessary for the company to feel that the company is in a good position and with its interests already established in those future orders. And the third category that might be helpful as well is to already have a sample of those future orders. So you still have some level of determination on these future orders, mainly when you're talking about price and quantity, for instance, but you already have beforehand something established by the parties on how these specific orders will be issued and how the parties should communicate for these specific orders. So I think that in this way, you preserve the legal certainty that the company needs for these service and to be provided and goods to be purchased in the future. But you also have some flexibility. Of course, if you don't have this opportunity, because it depends a lot on how the company will be able to manage the agreements and move forward. There is also the possibility of having one per jurisdiction, one per country. But then you lose basically the advantage of this framework, master agreement or umbrella agreement in general.
Definitely. I think one of the main ideas around this is to consider keeping the benefits of a master agreement, as you have already mentioned a lot of them. In particular, it's very interesting and I think essential as well that one of the main purposes of having one regional agreement as framework is to keep the consistency of key provisions that you will include and that you would like to have in the or guiding the whole relationship across the countries. So you have thinking about these particular provisions. You mentioned some of them. Others might be dispute resolution, choice of jurisdiction, venue, governing law as well. So as in-house counsel, those are some of the specific items that you will also like to keep in mind to have uniformity in a master agreement. But what about the cons of having a master agreement if there are some cons?
Yeah, I think it is a key point that you touch, because as I mentioned before, as the negotiation is usually more complicated because you're trying to address several interests on both sides, because if it involves several jurisdictions, it will involve several jurisdictions for both sides, not only one company, not only the other company, but both, because it's supposed to work for several jurisdictions on both sides. So I think the main con is that it's much harder to negotiate and reach terms that are good or useful in general. And because of that, sometimes what happens is that you have a framework agreement too flexible or too open, because as it is hard to reach consensus in some topics, the parties may decide to leave more open language, more flexible language, and then you may end up in a situation where you have a framework agreement, an umbrella that doesn't cover essential elements. So you need to articulate in the agreement what the parties really want from that agreement. And sometimes that's fine. It's hard to negotiate. It's hard to reach consensus. It's hard to have a language that actually helps or are very specific for certain situation. But you need at least to try to explain in the agreement what the parties meant by that, what the parties intend by that. Because if you don't do that, you're gonna leave for a third party in the future to interpret your contracts for yourself. So the main aspect here is to take in consideration from the cons is not, of course, being flexible is important for this type of agreements because of future orders that are related to it. It's the nature of it, but it cannot be that flexible so it doesn't help in the future, because the parties will have to get back again on the table to say, okay, we have this provision, but it's not clear what we wanted from there. And the main challenge to be taken in consideration, I think it is in terms of having something flexible, but giving guidance, giving the actual framework for the future relationship of the parties.
Yeah, I think what you mean is there's a delicate balance between having something that can be enforceable and giving the flexibility also to work for all the countries. And it can be challenging, as we know that we have different key stakeholders in the countries wanting to, protect their part of the deal. So definitely important to consider that although a master agreement would work, there are certain considerations that need to be given free to be able to work. So what other aspects, Mateus, to take into consideration while doing or trying to close a master agreement?
I think that what you mentioned, it's basically the same thing that I have in mind. You need to be able to articulate that provision and that clause in a binding way, so it gives certainty for the parties. It's basically what the parties are looking for when they negotiate agreements in general. And there are several topics that may be considered. I would say ethical rules of the companies, these are important because once you establish that, everything goes easier. Time, periodicity for performance review, it helps as well. Forms of communications, interactions between the parties on what will be agreed, how it will be agreed. And more importantly, parties need to take or have in mind all the time that they are establishing the framework, the master agreement for the future orders. So they don't need to, in that specific moment, to make future commitments. Because if you do, you already have, you're leaving or you're taking out the actual advantage of the master agreement and the regional agreement, because you are already establishing beforehand how it will be performed. So it's important to keep in mind the need to establish the in a binding way what is really essential for the parties in that specific regional agreement, but leaving for the future the real needs, because this gives the flexibility to say that in one specific month you're going to need 100 and the second month you're going to need 300, you know. So I think there are several other aspects to be taken into consideration, but the main message here is try not to commit on the future, because this is exactly the purpose of these regional agreements, umbrella agreements, where you can establish upfront what's really essential and leave how the business progress, the specific details, the specific needs.
Interesting, your view on, all those other aspects that should be considered in a regional agreement, such as the ones we're talking about. Other aspects that we have briefly mentioned relates to choice of jurisdiction and venue, governing laws. Why is this an important aspect of a regional agreement?
Yeah, I think that I'm gonna take first governing law, because when you have several individual agreements, it's normal to to have more localized governing law. So if you are dealing in Brazil, you're gonna have Brazil as governing law. If you're dealing in Argentina law as governing law. When you are talking about a regional agreement, if you leave for the specific orders to have one governing law for each, it's going to be really hard to have one resolution or one uniformity on how to resolve the disputes. So ideally, you should have the same governing law for the contract, for the regional agreements. And of course, you guarantee this way that if this law is good or bad, it's another topic, but at least you're going to have only one governing law regulating the parties' relationship. And in general, it helps. It's always easier to deal with one governing law, even if there are aspects of this law that's more favorable to one party or to the other, but at least you have some uniformity than having several. And jurisdiction is also key, because you need to have courts, or if you choose alternative dispute resolution methods, you can have you should have something that works fine. Otherwise, you're gonna spend a lot of time negotiating the provisions and having a good body of protection, and you're not gonna have someone to enforce that in your behavior. So I guess that in general, when negotiating the agreement, parties tend not to think about how disputes related to this agreement will be solved, because people in general, we are optimistics, and we always think on the positive side and say, okay, we will never have a disagreement, we will be able to negotiate, so we don't need to pay attention to that. But in practice, we know that having a helpful body to solve disputes also help the party to behave properly during the contract performance, because knowing that if someone steps outside, there will be someone to adjudicate properly, that helps the party to perform well and perform properly what was agreed before. So I think these are two key elements of any master agreement.
No, I agree with you, Mateus, in terms of, you mentioned that when you're closing a deal, you don't necessarily think about, when the deals go south, but
Yeah.
definitely it's important to consider also if you have an issue or controversy during the term of the agreement, then it's also very important to think about the rules that will govern your deal in terms of dispute resolution or other issues as well. So in terms of governing law, are there jurisdictions better than others in relation, particularly to insurance law? Do you have an opinion on that?
I'm not of course, from my perspective as Brazilian counsel, I know very well our view. Maybe you being responsible for Latin America may have more, you certainly have more knowledge than me on how it plays in all the jurisdictions in Latin America. But what I think it needs to be looked at by an in-house counsel is probably two ways. One, the protection that the governing law gives to the contract itself, and the pacta sunt servanda, and the provisions that the parties are establishing. Some contract law is more flexible than the other. So I think this is one key element to be taken into consideration. So contract law as a general, how it is protected by the specific governing law. And the second one goes exactly to what you mentioned, is taking consideration the specifics of the agreement or the contract itself. So insurance law, how it is seen by the governing law and jurisdiction where the parties might end up choosing. And for instance, insurance law, I know that varies a lot from country to country, regulations. So of course, when you're talking about this specific field, see how regulations work, I think it's essential. And depending on the agreement you have at hand, the service to be provided or the insurance to be sold goes directly to the end user, the consumer. And then you also need to take into consideration how for instance, the consumer law in that specific jurisdiction works. In Brazil, our consumer law is very protective, and one may say that's too much protective on behalf of consumers. So this is something that may not be directly related to the master agreement, because the relationship will be more company to company. but this may affect indemnifications and sort of problems that the insurance company may end up in the future. So I think two general aspects, contract law and specific law, needs to be taken in consideration. And when you're going to the specifics, not only from the regulatory perspective, you need to be analyzed, but also other implications such as consumer law. So there are a lot of aspects to be taken in consideration, but you certainly have a lot of experience in Latin America and you know certainly better than me which law will protect better interests and be more friendly to business.
Definitely, and I'm no expert in any particular country, but definitely, having done business in the region for a while, what we've heard from some insurance attorneys in Latin America, it's that maybe Chile, it can be considered as advisable because they consider that it is efficient, is fast, and is a sophisticated country in terms of insurance. So in that sense, again, no particular opinions. We're not particularly giving opinions on what country to choose, but definitely
Sure.
it's good to have a conversation around what you just mentioned, and also consider countries that are more friendly to or knowledgeable, at least knowledgeable about insurance, and they can manage,
I could have said Brazilian law, but I think giving more a broad perspective. So in each case, the in-house counsel with the outside counsel can decide. I think it's more helpful than just saying Brazilian law. So and your perspective is very interesting to also add more on this. And you're exactly right, but you have to take in consideration for the specific case is what works better to give actual security to the company, because that's the whole purpose of having more uniformity on how the deals are negotiated and performed with the company.
Mm-hmm. Yeah,
So,
definitely. We talk a lot about dispute resolution, and I'm wondering, do you have an opinion or a suggestion about what is the best alternate dispute resolution method, if you have one, and why?
yeah, I think that's something that I mentioned before on, not having several individual contracts, one per jurisdiction, and having a regional agreement that gives you more, broader view on the subject. You also, it's natural that you also take the case out of courts and gives them more a perspective on, for instance, arbitration, which can be more delocalized. Instead of having local courts, you can have an international body responsible to resolve your dispute. So as you're talking about these regional agreements, my tendency would almost certainly be to avoid local courts and give more international approach to the contract. But more importantly than establishing your adjudicator, and I think this is key, but I think more important than that is for the parties to try to establish how they can avoid that, and having in mind how they can avoid that. I think that, for instance, having a multi-tiered dispute resolution method, or a step-by-step method of dispute resolution, where you establish the need for having first negotiation, you know, and leaving the local jurisdictions and going to almost an upper level to negotiate and try to solve the potential dispute. I think it's key. I also think that specifically for this sort of agreements, having a mediation clause might be very helpful too, because even when the parties are not able to negotiate, you can have someone specialized on that, helping the parties to actually solve the problem instead of going to a regular dispute. Might help as well, because um, all the work to have a regional agreement cannot be just throw away because of one small disagreement. Sometimes it's inevitable, but having ways to resolve that in an amicable way, I think it's always a smart move when you're talking about a regional agreement. So I would say essentially to try to take out of local courts in general. Of course, it depends a lot on each case, but in general, my perspective would be that. And also give the parties the opportunity to negotiate, force them to negotiate by themselves or with the assistance of a professional like a mediator before going to a real dispute with someone adjudicating that. So taking consideration the needs of regional agreements, I think that this would be my perspective on that.
Yes, and also to consider there are certain countries as well that might limit the methods that can be used. Some countries also kind of regulate if the, in particular related to consumers, that you cannot prevent them into going into court. So all of those aspects as well will need to be considered when choosing any dispute resolution methods. But also in terms of um, other aspects that you might consider important or relevant for regional agreement, in particular related to insurance. Any other advice?
I think in the same line of what I mentioned, of having a method that gives the parties the opportunity to talk again, and sometimes take the dispute from a local level to a more higher level in order to avoid losing all the efforts and the relationship of the parties. I think that for this specific type of agreements, when the parties decide to give uh, to themselves the opportunity to, from time to time, revisit performance numbers, in my perspective, it's always helpful, because instead of saying, okay, this is it, and let's see how it goes, you are already establishing beforehand some milestones to go back to the table and see how things are going and if something needs to be changed before you get to the point where you have a disagreement. So, and if everything is fine, parties may not even need to use that opportunity. But it's interesting when you see the agreement already providing a specific opportunity for the parties to sit on the table again and see if it's going well, if it's not going well, what's not going well, what can be adjusted. And when you do that in a proactive way before parties start to have disagreements, I think it works. It works very well.
Now, I definitely agree with you on that view. It's very important, and those type of stages where you will have not necessarily to renegotiate, but to measure the profitability of your deal, compliance of your program. So those are very good opportunities to see how your program is going, how uh, every party in the agreement is fulfilling its obligations. So definitely very good advice. And I think that in these times where we are unfortunately living the event of the pandemia, it's also good to have that in mind, and how to keep in mind that in particular, the force majeure provisions in an agreement as well will give you an opportunity to also revisit your agreement in a unfortunate and unforeseeable situation like this. So, having that in mind, do you have any advice in terms of how to look now into this type of provisions, when we know if you're entering into a new agreement, now you know that this is of course possible, and what will be your advice in terms of taking that into consideration while contracting in COVID times?
Yeah, I think that the first aspect to be taken in consideration is how the governing law deals with the force majeure in general. There are countries where the parties need to specifically regulate in their provisions, in their agreements, how force majeure applies. In Brazil, for instance, there is a provision on that in our civil code that will apply to all contracts. If the parties establish a force majeure exception or not. So this is a first step. But beyond that, I think it's basically what we discussed a lot here in these regional agreements where you have several entities involved, the necessity to really talk to each other and negotiate in good faith. As you leave the specific orders for the future, in a case of a COVID-19 situation like we are having now, the parties may just stop placing new orders. But it's important not only to behave accordingly to the situation, but also, make sure that everything is immediately communicated to the other party in good faith. Also mitigate damage. You cannot just leave the situation as it is, and after several months you decide to communicate to the other party. It's necessary to immediately take the measures, communicate, try to negotiate. Courts are not going to be able to resolve all the conflicts that may arise from COVID-19 situations. So again, we go back to the necessity of having a good relationship, open communication, being able to treat the other party in a fair way, and again, mitigate damage, try to be as fair as possible in such situations, because it's extraordinary, never happened before, and no one knows exactly how to deal with that. It will be, of course, case by case, but I think that everything that we discussed here and talking about these regional agreements, it is aligned with the measures that the parties should take, because if you have an agreement to work for several jurisdictions, of course, those jurisdictions will be affected in different ways by the pandemic. It's not going to be the same. So it reinforced the need of immediate communication and the parties being open to talk to each other and see how to address the situation, because much better than having someone deciding your dispute for you is you being able to resolve by yourself and with the cooperation of the other party. So I think that's the overall idea.
Yeah, and I agree. And I would add, that knowing beforehand or trying to plan ahead for a situation like this. Hopefully, we will never have something like this ever again. But to foresee that in the different countries you will have different restrictions, and that will at some point prevent you of complying, I'm sorry, with some of your obligations. How do you plan ahead and know that you're not going to be able to comply with those obligations, but also to plan ahead and see what will be the mitigators, and try to reduce your liability in
Exactly.
for not complying. But definitely, I think that all this that we have been discussing, Mateos, gives a good perspective of what to think when you're entering into a potential regional agreement with a client. I hope that gives you our audience the all the alternatives, or at least some of the alternatives that you have to try to put in place an agreement that makes sense for multiple jurisdictions. If you have heard as pieces of a puzzle, you can put together the different alternatives that we have presented, and a lot more. And at the end of the day, build an agreement that will help your company and will be satisfactory to the parties involved. So thank you, Mateus, for your
Thank
participation.
you.
And thank you to Gabriela Rosier as well for inviting us. And now we're open for questions. Thank
My
you.
pleasure. Thank you so much. Thank you.